On May 25, 2018, the General Data Protection Regulation, also known as the GDPR, went into effect in the European Union. For businesses in the United States, compliance with this European Data Protection Act is a must if the business has customers engaging it from the EU. In this video, I'm going to discuss the steps that you can take as a business owner to help you comply with this General Data Protection Regulation and sort of break it down to help you comply with its requirements. And your legal lesson starts now. Hey, how's it going? I'm Andy Contiguglia, a lawyer here in Denver, Colorado. I'm bringing you your legal lessons in business about the law in business. If this is your first time visiting this channel, please like it, please subscribe, and then you can stay up to date and get a more detailed understanding about the legal problems that you can encounter while running and managing your business in the United States. Now just remember, this video is just for information and entertainment purposes only, so please seek an attorney's advice if you think that you need a more detailed description and compliance issues. But the key here is to get your new policy implemented as quickly as you can and as quickly as possible. The nice thing is that many GDPR's main concepts and principles are much the same as those in the previous Data Protection Act of the EU, the DPA. So if you are complying properly with the law prior to the enaction of the GDPR, then most of your approach to compliance will remain valid even under the GDPR. And that can be a really good starting point for you to build your privacy policy from. Now, when we're talking about the GDPR, we're talking about how businesses obtain and protect consumer data. In its simplest form, we're talking about your name, email address, the uses of cookies, or how a business gets an IP address, and when a business starts collecting and gathering that information. So as you gather that information, you have to be transparent to the consumer about how you plan on protecting that information and how you plan on using that information. The GDPR places greater emphasis on the documentation that data controllers must keep to demonstrate their accountability under the GDPR. Failure to comply with the GDPR can result in hefty and significant fines. But we'll talk about those a little bit later toward the end of this video here. All right, but first, let's get into some of these details. All right, awareness. That is the first thing. It's important that your business actually identify whether the GDPR is even going to apply to it. If your business maintains EU customers and gathers personal data from them, it's likely that the GDPR will apply. When you're talking about information that you actually hold, you should document what personal data you are holding from your consumer, where it came from, and who you actually share that information with. The GDPR requires that you maintain records of your processing activities. So for example, if you have inaccurate personal data and you've shared this with another organization, you will have to tell that other organization about the inaccuracy of the information so it can correct its own records. Now keep in mind, you won't be able to do this unless you can actually tell what personal data you hold, where it came from, and who you shared it with. So this should be documented within your business. In fact, being able to document is a requirement under the GDPR's accountability principles. When you collect personal data, you will have to give the people your identity and how you plan on using their information. So everything here has to be of the utmost transparency. How will you do this? You'll do this through the enaction of a privacy notice within your business. You'll also have to explain the lawful basis, the reason for processing the data, your data retention periods, and that people have the right to complain to the ICO if they think their data is being used inappropriately. Now, the GDPR also enacts a number of individual rights under it. It includes the following rights for individuals: the right to be informed, the right of access, the right of rectification, the right to erasure, the right to restrict processing, the right to data portability, the right to object, and the right not to be subject to automated decision-making, including profiling. So things like retargeting and acquisition ads, directing things to people, that's not going to be allowed unless they agree to it. So think of it this way. How would you react if someone asked you to locate their data and delete it? Could this be done with relative ease? When it comes to subject access requests, how are you going to handle requests to account for the GDPR? Well, you can't charge for those requests. You'll have 30 days to comply with the requests, and you can in fact refuse or charge for requests that you find to be unfounded or excessive. However, if you do refuse a request, you must explain why, and that person has a right to complain to the ICO and seek court intervention. You must have a lawful basis for processing the personal data. A good rule is only collect the amount of data needed to complete the task that you need the data for. So for example, think of an opt-in for a newsletter. Under those circumstances, you should only need an email address, so the collection of other personal data might be excessive and unlawful. So in any event, make sure you identify the lawful basis for your processing activity within your privacy policy. Now, when it comes to issues of consent, if you think acquiring your prior consent is problematic under the GDPR, it's best to refresh and gain new consent from your users. Remember, consent must be freely given, it must be specific, informed, and unambiguous. There must be a positive opt-in. Consent cannot be inferred from silence, and pre-checked boxes or inactivity are also not allowed. And these must be separate from other terms and conditions of your usage. And you'll need to have simple ways for people to actually withdraw consent. In addition, you have to have consent be verifiable, and individuals generally have more rights where you rely on consent to process their data. So again, if you're worried, get a fresh GDPR compliant consent moving forward. When it comes to children, if your business relies on a child's personal data, like social networking or social media, you might need a parent's consent to lawfully process the personal data. And again, this consent must be verifiable. The GDPR places consent for processing at 16 years old. So if you're collecting data from anybody under the age of 16, you need parental consent. Now, when it comes to data breaches, make sure you have the right procedures in place to detect, report, and investigate any types of personal data breaches. You must notify the ICO if there is a personal data breach where it's likely to result in a risk to the rights and freedoms of individuals. So if, for example, it could result in some type of discrimination, damage to reputation, financial loss, loss of confidentiality, or any other type of significant economical or social disadvantage. If the breach is likely to result in high risk to the rights and freedoms of other individuals, you will also have an obligation to notify those concerned directly. That's in most cases. Data protection by design and data protection impact assessments. This is also known as the DPIA. And this is going to be required where data processing is likely to result in high risk to individuals. For example, if you're using a new technology, deploying a new technology, where a profiling operation is likely to significantly affect individuals, or where there is a processing on a large scale of the special categories of data. Under those circumstances, you're encouraged to seek an opinion by the ICO to actually make sure that processing complies with the GDPR. Now, in some circumstances, you may be required to appoint a data protection officer. And in this case, you should designate someone who actually takes responsibility for data protection compliance and actually assess where this role will sit within your business structure and the governance arrangements within your business. So, under these circumstances, you will be required to designate a DPO if you are a public authority, unless of course you're in a court system acting in their judicial capacity. If you're an organization that carries out the regular and systematic monitoring of individuals on a large scale, or an organization that carries out the large-scale processing of special categories of data, such as health records, information about criminal convictions, and things like that. Now, the GDPR is obviously international, and it applies to those of us doing business internationally. So if you operate in more than one EU state, you will need to determine who your lead supervisory authority is under the GDPR. Generally, that's going to be the state where you actually maintain your establishment business. However, for many of us, where our business is located in the United States, well, we're not exactly sure how the EU is going to be actively enforcing this regulation without actually having a physical address located in Europe. But keep in mind, this still applies to US-based companies who are gathering information from people in the EU. And when it comes to those fines, it can be up to 20 million euro or up to 4% of your global revenue. So these hefty fines going to put a company out of business who fails to comply. So I hope you found this video educational. Again, please like, please subscribe, please leave a comment down below. I'm real curious about whether you do business in the EU and what steps that you are taking to become GDPR compliant. Thanks for watching this video. Good luck.